We are going to jump right into our second panel on regulation and the future of the legal profession. Again, we have three fantastic panelists. Jonathan Sommier is Legal Services and Support Counsel at the Nova Scotia Barristers Society. Kathleen Layton is a Senior Strategy and Innovation Lawyer at Stewart McKelvey. And Jessica Lumiere is Senior Associate at Torys Legal Services Centre in Halifax. And our moderator for this panel, Leo Bourgeois, is an article clerk at the Initio Technology and Innovation Law Clinic here. Over to you.
Thanks for the introduction, Mike. As Mike mentioned, my name's Leo Bourgeois. My pronouns are he, him, and I'm the article clerk here at the Initio Technology and Innovation Law Clinic. Really excited to be here moderating the panel today. Just want to make a few notes. So at the clinic, we're really committed to advancing access to justice. We provide low-cost legal services and legal information to startups and organizations, in the technology space. One thing, that's becoming very apparent to us, especially with, the discussions around AI or how its design and deployment can reinforce systemic discrimination. And it really ties into, what we're doing here at the clinic in terms of learning about the Ruck Report and the Truth and Reconciliation Commission's calls to action and other standards the legal profession needs to be considering. So I just wanted to say that Dalhousie University operates in the unceded territory of the Mi'kmaq, Wolastoqey, and Pescamawakate peoples. These sovereign nations hold inherent rights as the original peoples of these lands, and we each carry collective obligations under the Peace and Friendship Treaties. Section 35 of the Constitution Act 1982 recognizes and affirms Aboriginal and treaty rights in Canada. We also recognize that African Nova Scotians are a distinct people whose histories, legacies, contributions have enriched that part of Mi'kma'ki known as Nova Scotia for over 400 years. So to start off, and maybe we'll start with Jessica, wondering if you could all briefly introduce yourself and share your perspective, just kind of briefly on how AI is already shaping the legal profession in Canada.
Sure, thanks, Leo. So my name's Jessica Lumiere. I've been a lawyer for 22 years, and I started my practice as an IP lawyer at Torys many moons ago. And then I ended up going in-house at a large financial institution, which is really where my interest in technology and more on the commercial contracting side really arose. So I was there for about 11 years. I was involved in all kinds of things, including, the rise of cloud, which at the time was like a big deal, much like AI is today, and as well as blockchain and AI. So lots of conversations in that context. And then my husband and I moved out here in 2009, and I was still with the bank, and Torys opened an office shortly thereafter, and I sort of knocked on the door and said, "Oh, look, you're here, I'm here, I have all kinds of ideas, and you're starting a new model for law firms, and so I'd love to be a part of that." So that's how I got involved with our Legal Services Center here in Halifax. And if you don't know about us, maybe just a quick word to explain. So we operate the office here as a sort of, you can think of it as like a captive alternative legal service provider. So we do some client-facing work, but much of what we do is actually in support of our other offices. So all of the things that the previous panel mentioned, things like due diligence and e-discovery, and a lot of our clients still do an awful lot of NDAs in various capacities, things like that. So we have really, as one of our fundamental mandates at the LSC, is to innovate, to be efficient, to figure out how to do these things that are high volume and often repeatable, but also that clients really are starting to not want to have to pay our Toronto Torys prices to do, and other law firms to do. So I guess that's the sort of my background. And then maybe to the second part of the question, how is AI shaping the legal industry? I actually think I actually think if I could, like, I think that question is how is AI shaping all of us? Like, I the legal profession doesn't operate in a vacuum. Like, and I always think about, I look at my kids, like, you guys are growing up in a world where everything is AI. We talked in that earlier panel about how it's hard to tell kind of what is AI and what isn't. And so I think it's really interesting. Like, I was at a Cantech meeting 2 weeks ago. I don't know if anybody else in the room was at that meeting, but we talked about AI. It was one of the most like interesting animated conversations we've had in that group in a long time. So, there's lots of jostling we can see in the media between, governments and big tech about innovation versus regulation. I had in my notes here to tell you guys, like, Tori's just started its first AI practice group. And you might think, wow, that's like, it's 2005, you're just doing that now. But, there's so many different aspects of every other practice area in our firm that play into conversations about AI that, it was all sort of in disparate places with different people before we could sort of organize it into like a community of like, let's talk about AI. And I would just add, we're expected as lawyers to not only use AI in our practice, but also to advise our clients on the risks and challenges with AI. And, I think it's coming at us from all sides. It's part of who we are in our private lives. We bring it to work. We use it as a tool at work, and then we're advising our clients on it. So it's a lot. It's shaping us at a remarkable pace, and it's fascinating.
My name is Jonathan Sommier. I'm counsel with the Nova Scotia Barrister Society. You know who we are and you know what we do. Soon to be members in the room, or already members, some senior members even. Happy to see all of you here today. My role is within the legal services support team, so the reason why I'm here is because this is kind of a hot topic or so, I hear. Nothing will get a lawyer's attention faster than telling them they're going to be out of a job soon. And I think that is the first way that AI has sort of started reshaping the legal profession. Is it's coming with a lot of hype. It's coming in hot. And your job as lawyers and as law students is going to be to separate fact from hype. At the end of the day, you're the insured professional who's going to sign that letter, who's going to file that memo, who's going to have that conversation with the judge, who's going to argue that case with opposing counsel. To take words from the Nova Scotia Justice Department's policy on AI, rule number 1, assume the output's wrong. Assume the output's wrong. And that has to do with a lot of the hype piece around it, right? So I think you need to just go back to the basics sometimes and remind yourself that this is a new tool to do your job. Just like email was a new tool to do our jobs 30, 40, 50 years ago, just like fax was a new tool to do our job 100, 200 years ago, right? The code of professional conduct is still there. That lays out your obligations to your clients, other counsel, and your relationship to judges and the courts. The Nova Scotia Barristers Society regulations still exist. You still have to follow them. So I guess my number one message is try to not buy into the hype too much. Think about who you are, what your obligations are, to whom they are, and how you need to focus on using this deal, on using these things as tools in your toolbox, as opposed to the be-all and end-all of how you now practice law.
I'm Kathleen Layton. I'm a senior strategy and innovation lawyer with Stuart McKelvey. I've been with the firm for about 10 years now, and I spent the first 5 or so years doing corporate immigration law before I transitioned into our strategy and innovation department. And I've been getting more involved in AI at the firm over the past few years, not because of any specific experience I have or technological affinity, but more because of my work with process improvement and strategy development. So I think around the end of 2023, our firm kicked off an AI task force, which was mandated to come up with an AI adoption strategy for the firm. So that's something that I helped to lead and roll out, and we've since sunsetted the task force, and now we have an operationalized AI and technology committee that I'm on the steering committee for. So that's a little bit about my background and how I've gotten involved in AI. In terms of how I think it's already shaping the legal industry, I would agree it's a tool in the toolbox. I would say, based on my experience so far in the short term, there's not a dramatic change to the legal profession right now. I think what we're seeing, and I'm sure we'll get into this a lot more in today's panel, but really exorbitant price tags on some of these technologies. It can be cost prohibitive for a lot of lawyers to adopt, and the quality in some cases is such that you might spend as much time vetting the output, as much time or more vetting the output than it would take you to kind of get to that same endpoint the traditional way. So we're not at a point yet where we're really seeing significant time savings that are translating into significant cost savings. But I definitely think we can see the kind of trajectory that AI is on. And if this pace of technological change continues as it has been, we can definitely see more significant impact to the profession. And I think what we're looking at is things like, some fundamental changes to what we do as lawyers. It was talked about a little bit in the first panel, but, shifting towards more strategic advice, more complex legal advice, and away from some of those tasks that you didn't actually go to law school to do. So in some ways, more fulfilling work. We'll definitely see changes down the line to how legal services are priced for and delivered, to the type of education, skills, and competencies that we need to build to continue to remain competitive, and changes obviously to the kind of regulatory framework and the kinds of risk mitigation efforts that we need to have in place to make sure that we're using AI responsibly. But I liked the quote, maybe Jane, it was you, that said, AI is not here to replace lawyers, but lawyers who leverage AI will replace those who don't. And I know when you're in law school and you're hearing about AI, there can be kind of a doom and gloom tone of, why am I even here? There's not going to be a job for me at the end of the day. And I don't think that's the case. I think, hopefully we view this optimistically as a challenge to see how you can hone your skills and develop your skills to make yourselves more competitive in the marketplace. And there is definitely still a role for you to play. We've talked about the human in the loop. We've talked about it being a toolbox, but not something you can over rely on. So we still need lawyers for sure. And Jessica, if it makes you feel better, AI is also a relatively new practice area for our firm. We've had privacy groups and IP groups, but it's really kind of coming together as its own practice area for the first time, I would say, for a lot of firms.
Awesome. Well, yeah, really appreciate everyone's insights and learning more about your backgrounds as well. And I'm sure for like a lot of the younger lawyers in the room and some of the law students as well, it can be reassuring to hear that, you're not going to be replaced while you're, pursuing your legal studies. But I do think there's kind of a gap in terms of having students like disclose the use sometimes. So still trying to figure out how to navigate that a little bit.
And Leo, on that point, I think I might even argue that the role of the lawyer has never been more essential than it is now, because the buck stops with you. What's happening right now is everybody that has a computer at their home is thinking, well, I don't need to pay a lawyer. I'll just use ChatGPT and it'll give me the answer. There's this democratization of legal information that's out there, and people are taking it for cash. And you'll see people going to small claims court representing themselves with all kinds of things that are wrong. And at the end of the day, they have no one to turn to but themselves. So at least as a lawyer, by the way, also be prepared for your clients to challenge you with that stuff, right? Jonathan, I read your draft brief, but actually I went on ChatGPT last night and it's like Google, self-diagnosing on Google and going to a doctor and arguing with a doctor because what you found on Google was this and not that. So I'm making the reverse argument that really the role of lawyers has never been more important than it is now, because You are the final decision maker. You are the one with the tools, the training to make those what determinations are relevant in whatever context questions are posed or that you're operating in. And at the end of the day, if something goes wrong, you're the insured professionals. If you make a mistake, your clients can access compensation funds. If ChatGPT makes a mistake, it doesn't care, right? So, in a way, I would say it's never been, lawyers have never had a more important role than now.
Such a great point. I think kind of goes to what like Jessica was saying at the start too, around like advising clients on the risks of AI. And I don't know if like anyone else in the room has experienced like clients coming in with like an AI note taker to your meeting, right? And could be like a free open source software. So definitely interesting to consider. So maybe for the next question, we'll start with Jonathan. So, you know, we've heard from the first panel about a little bit about like how AI is being used in different areas of the legal profession, you know, contract analysis, legal research. We heard about, you know, some like document automation. I'm curious if you think like, you know, the more AI becomes adopted in legal practice, do you actually think that's going to, you know, enhance efficiency or access to justice? Or do you think it's going to like create barriers for, you know, lawyers and generally, maybe even those in like their early career who can't really like distinguish, you know, whether an output's right or wrong?
Both, and it depends, right? When you think about AI and access to justice, you have to be careful because just because it's out there doesn't mean it's right and doesn't mean it's helpful. So in a sense, just going back to the point I just made about this democratization of access to legal information, just because everyone has access to free Gen AI at home doesn't mean it's any good. So we're definitely not increasing access to justice that way. We may be increasing to access to legal information or quasi-legal information, assuming it's correct, which we can't. But if we take that in the context of a law firm, so let's make the argument that, well, because now lawyers can spend less time doing menial tasks and relying on AI tools to do it for them, that you could say increases access to justice, because then it creates a capacity void that can be filled with more clients, and thus you're increasing your capacity to serve more clients, and thus you're increasing access to justice. Again, at what cost are you prepared to do that? At what cost are you prepared to put complete faith in an automated system in order for you to take on more clients, right? You definitely have to balance that with, okay, there are some, and also we have to get away from the notion of AI as one big blob. There's different things that do different things, right? So generative AI, your chat GPTs, those large language models, but there's also, like we've talked about before, you don't need to go through thousands of bankers' boxes of documents anymore and put your sticky notes in. What if you didn't train your software well enough and you missed the smoking gun? What if, you get to the negotiating table at a judicial settlement conference and you go, man, I'm sure glad we saved thousands of hours paying Billy to review those thousands of boxes of documents, because now here we are much more efficiently, but your bot or your software or the piece of AI that you trained missed that your client had a previous accident that caused a similar injury. Your settlement goes down the drain. So at what cost are you prepared to blindly rely on AI? And there is no cost great enough. Certainly in my view, sitting here as, my friends at Leanne's have to write the insurance checks after that, right? So again, over-reliance, that's a clean example right there of over-reliance, and also lack of supervision, right? So refer back to your code of conduct, refer back to your regulations, supervision, ensuring a quality product, ensuring that you're competently doing your job, and that you're not letting the smoking gun escape because of software.
I was going to.
Go ahead. Yeah.
I would agree with a lot of that. I might take maybe a slightly more nuanced view of like, so in some instances, maybe e-discovery is a really good example where you're going through like banker's boxes, yes, but today we're talking about hundreds of thousands or millions of emails and documents, and there is no physical without AI version of that allows you to, like, 'cause otherwise you'd have to say, okay, well, we have 15 lawyers and it's going to take them 5 years, and then we'll let you know if we found a smoking gun, right? So ultimately, like, yes, I 100% agree there are certain tools that are good in certain use cases, but those use cases like are fundamentally going to require something like AI. It might not be in all cases AI, and there's different kinds of AI, but I think that, you know, it's going to be absolutely necessary that we rely on those tools. And I was thinking about, I thought it was a really good question because I hadn't really contemplated AI and access to justice yet. Like, I guess I hadn't really gotten there. I was at my desk trying to figure out how to use these things and how they work for the business, and I hadn't really kind of taken the next leap. But you know, my thinking was there's lots of really great examples and these huge class actions that we just, you know, are a good example for e-discovery, where actually like there wouldn't be any access to justice if you weren't using an AI tool. Then there's kind of, so from a client perspective, great. Then there's like products and services that use AI that are, you know, we've seen all these cases. Did they make the right insurance decision? Should facial recognition have been used? Did we miss a group of people in the hiring process? Like, all of those things are, you know, working their way through the courts, and we don't really have a good answer for that yet. And then I would say from a lawyer's from the legal perspective, we go to this performance. Like, AI has started with the mundane tasks. We use the word mundane a lot today, but that's where AI has started, you know, initially to sort of make inroads. And I think, you know, that's the bane of a junior lawyer's existence. So if you decide as a junior lawyer you don't want to use AI, you will be outcompeted very quickly, I think, or early in your career. And if you use it half-heartedly and don't really know what you're doing, you actually risk like worse. And I'll leave that to you, but disbarment, etc., bad reputation, which is like everything. A reputation is everything in the legal business. So in that sense, maybe access to justice, if you have, I don't know, fewer lawyers, like I was looking at it from different perspectives that are able to offer access to legal services. And the last thing I'll just say is this self-serve model, right? Which is like, people now can go out and not only have access to the data, and I think there's opportunity here for lawyers and law firms and junior lawyers, where people want to go and they want to, you know, there's AI tools that can help do this, help people have access to the system by delivering them the data and even the forms of documents in a way that is compliant with the requirements of the court. Or, you know, I'm a commercial lawyer, so, you know, it makes sense from a contracting perspective and that kind of thing. Like, so people can actually do some of their own, and they might not otherwise be able to afford a lawyer, and they may not otherwise be able to access that information. So that's.
Yeah, I think I would echo a lot of what's said. I do think the self-serve model inherently brings a lot more risk with it, because you just simply are taking that expert filter completely out. So, you know, is the average member of the public going to be able to catch those hallucinations, catch those errors, appreciate how the advice that's being given to them might not apply given the nuances and the fact scenarios of their specific case? And especially if we're talking about applications that might involve some element of decision making, these algorithms can have bias in them, and relying on that could really disadvantage certain portions of the population. And I worry that the public could actually be in a worse off place depending on how these applications are unleashed and what kind of filters there are in place without an expert. I think in the law firm model where, and you know, I totally agree with what's been said, our role as a lawyer is so important to translate what AI is providing, to make sure it's relevant to our client, to make sure it's accurate. I do think there is an opportunity to gain efficiencies in work and to lower the cost of some legal services, and that is going to make some legal services more accessible and more affordable. But it's not for all legal services, so it's not going to be for the kind of bespoke, high value, nuanced legal advice. It is going to be more for, honestly, the types of tasks that you might push down to junior associates. So you have to find a balance between getting lawyers involved in vetting the output, but still leveraging technology so you can gain efficiencies for your client. And piggybacking a little off something you said, Jessica, we have this obligation to provide advice to a competent standard of a lawyer, but I also think competency as a lawyer at a certain point has a crossover with technology as well, and I can't refuse to deal with my client by email and only engage in letter writing with them. Like in this day and age, that's not reasonable, and it's not reasonable to spend 3 straight weeks just manually going through documents. And frankly, human beings are fallible too. If you have that high level of document review, you're prone to miss something very important. So, it might come to a point where this technology is sophisticated enough that it's actually negligent to not leverage it well and to not know how to leverage it well. So, I would just put that out there as a consideration too. I don't think we're there yet, but I think we're kind of on that pathway.
Awesome. Yeah, definitely think we're on a pathway and there's opportunities ahead. And I guess kind of the next question leads into that a little bit, especially around kind of the points of the public using these tools, or clients, as well as access to justice. So I am curious, in Canada, legal regulators and law societies do set, strict rules around the unauthorized practice of law. We've seen the emergence of, different generative AI tools in the legal field that are available to the public. So I'm curious, maybe we can start with you, Kathleen, to kind of build off some of your points on the last question. With the AI tools capable of providing legal insights, do you think that AI generated guidance should be considered legal advice? And if it is, or if it should be, do you think who should be responsible for any of the errors?
A hard resounding no. So I'll echo. That's an easy one. Thank you. No, I'll echo what we've all said today, which is you are responsible for your work as a lawyer. You are responsible for providing legal services to the standard of a competent lawyer. I think a lot of people think of this as a new risk with generative AI. It's not a new risk. We've always had that professional obligation. If I'm a lawyer and I delegate a brief down to my fresh, well-intentioned year zero associate, and they, rely on a case that's been overturned, they don't catch that, I don't review what they gave me, I submit it right to the court. That's my bad. That's my work product. I signed off on it. I made that submission. I didn't check if that was legitimate. So regardless of how we get to that end point, we are responsible for the work that we're putting out there to our clients and to the court. So for sure, I think lawyers are responsible. I do also think that there is responsibility on the part of the application developers, and a heightened responsibility where they're marketing their applications for legal services, specifically because there needs to be some due diligence into selecting the data sets that they're relying on and making sure they're drawing from credible sources, making sure that they're ethical in how they market those services. You talked a little bit about hype. There's a lot of vendor hype. There's a lot of sophisticated marketing campaigns out there for legal tech that, it will say it can do X, Y, and Z, and then you trial it, and in fact, it can't do any of those things that it claims to do. So there's a little bit of responsibility there, and obviously when, you have to maintain this application you put out there, you have to be checking it for errors and remedying errors and fixing things that arise. So, you own your work product, but, on the person who's creating that application and putting it out there for the world, there's, a piece of responsibility, not for the specific output that you're putting your name on, but, for how the product works and how it's marketed kind of in a more general sense.
Yeah, absolutely. Agree with everything you said. The buck stops with you. I've already said that, but that's the bottom line. When you're using any of these tools, whether it's to help you do contract review, whether it's to help you draft pleadings, whether it's to help you with your research, case law research, the buck stops with you at the end of the day. And don't just think of these, especially when we talk about query engineering and those large language models. There's the right and wrong scenario. So for example, I did a piece with the CBC where the reporter asked me, can we start with you just typing a question into ChatGPT and seeing how quickly it spits out the answer, and we'll film that as an intro shot? Well, I asked, what is the general limitation period in Nova Scotia? The general limitation period in Nova Scotia is 6 years. Hasn't been that for 14 years, something like that. But it,
Filming?
but yeah, they still kept it. But it's not all this to say that it's not just right and wrong. It's also, and again, that's where the more experienced practitioners will pick up on that. But it's also about completeness versus incompleteness of an answer, right? If you have this big case that's 60 pages, Supreme Court of Canada decision, and you say, summarize this, it'll summarize it, but then you'll end up in front of a judge that'll say, yes, Mr. Somia, but wouldn't you agree that in your case today, it's really the dissenting opinion of Judge so-and-so that would be more relevant? And you go, I don't know. They didn't say anything about that. So it's not just right or wrong, it's completeness versus incompleteness of the information that you get there. And again, no, these things are not capable of giving legal advice. And in fact, now they've smartened up. If it detects that you're asking it a legal question, it'll say, I'm not a lawyer. If you want legal advice, please consult with the lawyer in your jurisdiction. So, no, and really just handle with care. Be careful.
You guys have said everything I was going to say, but I was sitting here thinking, like, I could imagine, though, that someday in the future, like, courts everywhere today are grappling with this question of who's responsible for the error, right? In all these different scenarios. And I could imagine a day will come, because I agree with you, I think, like, we're going to be relying on AI, and who knows what the next thing is, for a long time to come, and more and more and more. And there will be better and better guardrails in place. We will understand better how it works. We'll have, we'll have more experience with it and all that good stuff. But we used to, like, in the case law, they used to sort of go, at least the ones that I read, again, I'm not a litigator, but like literally they would stand in the courtroom and they go, I don't know how it works. Like, it's a black box. They call it a black box, right? They would just say, like, I don't know. It made the decision it made. What do you want me to tell you? Like, that's just AI. And I think someday in the future, I could see that, law firms, legal practice will rely heavily on AI, and that things will go wrong, and they'll, need to sort of defend themselves. And who is responsible for that error? I think is a really interesting question. Like, I think courts are getting better at looking at how does an algorithm, like, show me the algorithm, disclose the algorithm, tell me how it works. There's specialized courts now who only do, like, AI cases, which is interesting. And so, how does the algorithm work? What is the data provenance? What was the training methodology? Like, all of those things are kind of getting into it in more detail. And it'd be interesting, I think, it'd be interesting to see at some point, like, where the decisions will fall as to where the buck stops.
Yeah, for sure.
I don't, by the way, I think we should all just keep assuming it stops with us, but I think it'll be, at some point I could foresee that there will be a case like this for a law firm lawyers who are going through the same thing that we see in the products and services space.
Well, and not even just with errors, but with, like, security risks too.
Oh,
so,
yes.
If you're adopting AI as a firm, you need to have security protocols in place, but
Yeah.
you also would be negotiating to make sure that vendor has security precautions in place. And if information gets leaked, where along the chain did that happen? So maybe I put in something that I probably shouldn't have put in, but I was told that it was not going to be publicly available anyways, and now it is. So there's kind of a chain of blame that can be placed, and I agree that trying to find exactly where you pinpoint that in the process will be difficult
Yeah.
and interesting.
Yeah, interesting.
Super interesting. Yeah, I really think there's kind of this discussion too around the ethical side and the marketing aspect as well. I know one of the major legal research platforms was marketing themselves hallucination free, and then there was a report from Stanford that came out that said it was the most accurate of all of them, but it was 60% accurate. So
Their marketing team is hallucinating.
Yeah.
Yeah. So to move on to our next question, I kind of think it goes to a little bit of what we were discussing at the start, but there's kind of this traditional law firm model that's been in place for quite a bit of time. Somehow has remained resilient in the face of technological change, and AI starting to present new challenges to that. So especially related to billing structures. Many firms still rely on the billable hour model, but AI can reduce the time required for legal tasks while also introducing substantial subscription costs. So maybe we can start with you, Jessica. Do you think AI will fundamentally change like how legal services are structured, delivered, and priced? And how do you think like the profession can really like adapt to those shifts?
So yes, I definitely do. I think we can all agree that those changes are happening in some places quicker than others. So I think that some of us are law firms are still much more client driven. Like, so there's different approaches, right, to the business of law. So there's leaders in picking up everything and trying everything new, and some of the really big law firms have a lot of cash to throw at that. They have a massive client base. It's maybe a different approach for mid-sized firms or smaller firms or firms that are in a niche area. And so maybe that's just one aspect that we should think about when we're talking about this. But I would say from what I've observed is, and some of this is probably also, our law firm and our client base, but we tend to be a little bit more client driven in this way. And so while we are ahead of the game on certain, areas for using AI, like e-discovery and due diligence and other maybe like business process and workflow areas, I'm not sure that we would sort of do an about face tomorrow and say, hey, guess what? Like, we're not doing the billable hour anymore because we've come up with this whole new scheme. But I do think that the clients are starting to drive that conversation more and more. And I would even, I've seen, this used to be like a new and novel thing, but now it's like 5 years old, so I'm not even sure it's worth mentioning anymore. But C-suite executives are compensated now on things like, are they using innovative services? Are they requiring the services that they have? So like in a client, so like a bank, let's say our client is a bank, that legal department at the bank, that senior executive that runs that legal department is actually being compensated, their bonus and their compensation based on, are they considering innovation in the services that they're receiving from the bank? And so I think that's going to start to drive a lot of these conversations. I do think there's this weird place that we're in right now where we're sort of we know that there's we're driving efficiencies. It doesn't really work with the billable hour model. We're trying these AFAs, and we know that our clients are often asking for AFAs, but strangely we're still in the script place. I don't know if you've had this experience too, where our clients will go, we want an AFA, and we want you to innovate, and we want you to be efficient, and we want you to do all this stuff, but oh, by the way, how many hours did you spend on that? And so I'm not sure if it's because I'm not sure if it's because some of the lawyers in those client in-house law firms grew up in the billable hour, and it's just an easy mathematical way to think about it. But it can't be just that, because we work alongside consultants all the time, and the Deloitte of the world will come in and say, this is going to cost you $500,000. Nobody ever says,
they wouldn't even
that,
break it down.
right?
Yeah.
They don't even break it down. It's like a one-liner.
Yeah.
And we have to have this agonizing conversation about whether we ask the client for $5,000 more because our license fees for these applications are astonishing, right?
Yeah.
And so I'm not sure if there's a little bit of sort of cultural history there, a little bit how we've trained people, and then I've lost the thread, but that's what that's what I was thinking.
Yeah, I agree with all that. I think, and again, in the short term, I'm a bit more skeptical of where we are quality-wise right now. I don't think we're seeing the significant time savings that translate into cost savings that we can pass on to the client. And you mentioned subscription fees being exorbitant, and we're trying to figure out how to recoup those costs. So right now, no, but assuming that we get there, I totally agree. It will change how we deliver and bill for for our legal services, and you have to be very strategic about where you implement AI. And I think this came up in the first panel as well, but you can really shoot yourself in the foot and end up cannibalizing your own revenue, because it takes you normally 20 hours to provide a certain type of legal service, and your client is more than happy to pay for that in full. But now you're leveraging AI and you can do it in 5 to 10 hours. Well, you just lost 10 to 15 hours of revenue that you would have otherwise made. So that kind of high level, more bespoke work is probably not where you want to focus. For me, there's kind of two main areas that come to mind that are a focus, and one would be not gaining more revenue, but actually reducing lost revenue. So there are certain types of legal work and for certain clients and in certain industries where you might have capped fees in place or not willing to pay your standard rate, or we often see clients who have very specific restrictions around how many hours even you can bill for a particular type of activity. So let's use the example of a client that says, you can't bill me for more than 2 hours of research on any matter. In reality, it might take me 10 hours of legal research to feel like I did my due diligence to provide an answer that I'm confident in, but every hour I spend after that 2-hour mark has to be written down because the client, we've pre-agreed, they won't pay for it. So if I can leverage AI to get to that answer in 2 hours, then I can spend that time that would otherwise be lost revenue doing something else that I can actually bill for. So that's one way. And then another way, I think, is what you were touching on with the alternate fee arrangements. If you establish a fixed fee for something, you're getting paid that amount regardless of whether it takes you as many hours as you base that fee on or less. And so to the extent I can leverage technology to make myself more efficient, I can build in a better profit margin and maybe recoup some of the cost of that investment there. But it's not something you can just implement across the board. It really is looking at each type of legal work you're doing. How long did it traditionally take you to do it? How long are you taking to do it now with this technology, factoring a little bit of recouping the subscription cost. So it's difficult and it's strategic, but I think it's possible, and it's probably where we need to go. I think even before the kind of Gen AI hype, we have seen in the past few years more and more requests from clients for alternate fee arrangements anyway, but it is typically for the more kind of commodity-based areas of law, so the more predictable and routine tasks, basic contract review, basic will drafting. So I think those are the kinds of services that will increasingly be kind of packaging as a product and selling at a fixed fee.
And the question is there from an ethical perspective, who bears the cost of you becoming good at using AI? Which client is that charged to and how, right? Well, you either decide to invest a lot of time yourself, not charging anybody to really become good at this on your own time, and then bring in the efficiency. But then, as we alluded to, we're not there yet where we're seeing these massive efficiencies in service because we're all kind of new at this. We're all taking time to learn how to use these things, properly. So, it's probably going to be a very difficult conversation with the client to sit them down and to say, look, there's this fancy, shiny new tool I can use to write your brief. And in a year, I'm going to be really good at this. And it really wouldn't have cost you half of what it's going to cost you now. But now it's probably going to take me twice as long as it would normally would because I'm just starting getting good at this and I don't really know. So would you mind paying twice as much as I would normally charge you for this? No. Not a good conversation to have, right? So from an ethical perspective, very much a question that's front of mind is who is going to pay for you to become good at this?
Yeah, and I think you need to be strategic and when you are approaching things with an alternate fee arrangement in setting something that is beneficial for both parties. If it would have taken you 20 hours instead of setting the fixed fee at the 20-hour mark, maybe you charge it based on 16 hours and it actually takes you 14 hours. So the client gets savings and you have a bit of profit to kind of recoup some of the investment. So I agree with that. But, and definitely you can't charge someone based on 20 hours, not at a fixed fee. Like you give an estimate, it's going to take me 20 hours. In reality, it only takes me 10, but I'm going to value bill for 20 because that's what it would have taken me. So you have to be careful around, have you actually set an agreement with your client about that price? Or did you just give an estimate and you've agreed to hourly billing? And that's very different.
Yeah, really appreciate the insights. I think it's like a really interesting kind of like tension to the traditional model. So it'll be interesting to see how it changes. And I wonder too, like how much we're also going to see firms developing like their own in-house, like AI systems and being able to market that to clients as well as, we have the best like AI systems. So
Leo, can I just add? I have another. I just had another thought, which is, I wonder to what degree, like, firms are going to start using AI to answer some of these questions. Like, so not just in the provision of service, but in trying to understand how we provide a service and what it costs and how we try to estimate what it's going to cost. So there's a unbelievable wealth of information at every law firm about their clients and about how the law firm works, how the lawyers work, how we bill things, what we actually make on those files. And I think there's a lot of opportunity for AI tools to help us kind of model so that we're better able to answer the question of what should this cost and what is the work involved. So that would be interesting to watch.
yeah, that's super interesting. I really didn't like consider that angle as much before, so really appreciate the insight. So with that, I think we can move on to some Q&A as well. If any folks in the room have questions, feel free.
You're not going to ask us. I thought you were going to ask us a question about like students and what should did we talk that one already?
I mean, I'm happy to go for it. I'll leave it up to Mike.
I'm sorry.
Sure.
Ask your question. Ask your question. Then we'll.
So I work in the area of information access and privacy, and I'm following along the lines of Jonathan's warnings about professional liability. But AI really requires a fair amount of advice to your clients, and I'm not sure how many law firms or how many commercial operations now actually, they're starting to use AI, and the collection process of personal information is required to be stated pretty much up front. And if you're going to change what you're going to do with that information, or have a different use from what you started with in the beginning, you're going to be violating privacy laws across the country, both in the public sector and in the private sector. So, Mike, for those that don't have it, I'm sure all law firms have privacy policies, but they might want to include in a process there how they're going to use AI relative to the personal information of the clients that they have, and then in turn advise their clients to be sure that that's also in place. So that's one. Number two is, some of you may have noticed that the Freedom of Information and Protection of Privacy Act has had amendments proposed this week about the exactitude of your information request. And when it comes to emails, you've got to have a very high degree of specificity about the emails when you're making an access request. And if the government has put in place a provision that says if you don't have that exactitude, you can reject the request. So that goes back to your IT people. When you get a request for someone's personal information, if you're in the private sector under PIPEDA, the private sector law, you want to be sure that the search is done adequately based on the criteria. And actually, AI is probably already in use in those companies that hold the marketing firms or firms that deal in personal information, because they do a search and find command on their computer. So you want to be pretty sure that you're exact according to the new one. This is in Nova Scotia, it's not across the country. But I put it all together in one. There's some policy suggestions to avoid professional liability relative to dealing with personal information that I don't think have been discussed publicly, at least in all the research that I've seen.
And maybe just on the privacy point, I'm not a privacy expert, so I'm not going to give the answer to what I think on this issue, but I think there's an interesting debate with PIPEDA and consent requirements and what is a new use. So if I already have permission for my client to process their information for the purposes of litigating their claim, I'm using technology already. I'm using email, I'm using a document storage system, I'm leveraging technology. If I'm using AI that is training the model based on the information I'm putting in, that is pretty clearly to me a new use that they haven't agreed to. But if I'm using it and their information is protected and there's security in place where it's not leaving the confines and I'm just using it to do the work that I told them I was going to do, there is a question there and there is a debate about that. Does that require specific consent? Does it require disclosure? I do think having kind of a general disclosure policy out there on your site in your engagement letters and things like that is useful, but it is a question of whether you have to go to every single client and say, can I use AI for your work or not? And it depends on the application, and it depends on how you're interpreting the legislation, I think, as well.
That's very good. The answer is put it in place in the beginning. That generally what you do with all your clients in terms of research and other things about or comparing common denominators in terms of social demographic profiles, I don't think a lot of people would consider, even if it's de-identified or anonymized, that you have my permission to actually do that.
So now we're in the arena of data governance, which is my favorite topic. But so I do think like, maybe I'll just say, because that's like a whole other conversation, but when you're talking about AI, I think two of the topics that come up the most often in my daily practice of commercial contracting are privacy and data governance, like by far. So yeah, all really good points.
Yeah, and I think to the point on using AI and data privacy, so, you know, at worst, it might look something like an addition to your standard retainer letter that says that, you know, I'm going, and just like I would delegate a task to any associate, I may delegate some tasks using various AI tools, and, you know, just know that we're doing that. To at best really, you know, to push the notion of privacy to really reflect on the bigger notion of consent in the first place. Like, are you okay if I use artificial intelligence tools to work on your case? Some people will not be comfortable with that, and that is their choice to make. Your work product is your work product at the end of the day, but I think, like we just said, we're kind of entering a new sort of level of privacy, comfort, consent. All of these notions should be swirling around in your head as you're moving forward on any matter, on any client matter that you have.
Yeah, like, and the data governance piece of that is you have to now identify that whatever consent you've gotten from that person is X or Y or Z, and you have to follow that through forever in your organization as your policies change, as you're ingesting new data and figuring out what that data's provenance is and how it fits into the categories of data you already have, so that you know what you're allowed to do with it and not allowed to do with it, right? So.
Question. So a lot of the conversation has been about how lawyers can use AI to improve practice of client service delivery. But how can lawyers prepare themselves to face off against AI when your clients are having decisions made against them by AI, so insurance claims or job application, and your CVs is not getting through because there's been discrimination in the AI? So how can lawyers start to prepare themselves for this new world where your client is coming to you with an AI issue and saying, hey, you know, this decision was made, etc., and now we're on the other side fighting against AI?
I mean, I think it's a great question. Dare I say the answer is the same? Like, you need to fundamentally understand, be familiar with, and be comfortable with AI, whether you're using it yourself or whether you're trying to take apart someone else's case based on their use of AI. So I would say it's probably the same thing. Like, go be comfortable. Don't be afraid. You know, be curious. Figure out how it works. Even just in your day-to-day lives, like, start there. I mean, we've got a zillion and one apps on our phones that are using AI. Figure out, read the use terms of use. Wow, I know. We just clicked on those and they disappear. Yes, sure, whatever. I just want my picture with that color of lipstick on. But just, you know, just like, I would say start there and just make sure, like, all of the things we said I'm not sure if everyone here's for the previous panel, but take the courses at school, like, get comfortable with it, have a conversations with people, practice using it, and follow all the guardrails that we've talked about.
Yeah, and I think, as we were kind of saying, like, there's been elements of practice that have addressed those kind of issues in the past. We have privacy lawyers, we have IP lawyers, we have, you know, human rights lawyers, and there's a lot of those components in the example you gave, but it's kind of an interesting opportunity to really carve out in each practice where you're blending all of those things together so that you can respond to those kinds of questions from clients as well. So it is an emerging kind of standalone practice area.
It absolutely is. And you guys are going to be, like, the students in the room, you're going to be the experts in this space. Like, we're still stumbling around trying to figure out how this works, and we've got all our like preconceived notions about it, and we've also got our habits and our like fallbacks and our kind of like, by the time you've been practicing for 20 more years, like it's hard to change. You want to, but it's hard. But like you guys are going to be the people that we're relying on to use these tools and to do this work. And so it's really, I think it's a wonderful opportunity to be the experts in this area carefully.
Yeah, that's a great question. And as easily as you might think, well, that starts with, was this decision a decision that should have been made by a computer in the first place? And we know that the federal government, for example, has set parameters that certain types of decisions, for example, as relate to citizenship or et cetera, cannot be made by automated decision makers. They have to be made by humans. But it's going to start getting really tough to peel the onion back to the really, was this decision made by a human or not? And was a human supposed to make that decision or not? So, you might just have nailed an emerging practice field there, for sure.
And can I just add, just because I love this conversation, I would also say I haven't, in all the years that I've been practicing, I haven't had a single significant deal where the first piece of information we sit down and talk about is who are the players, what are their drivers, what are they looking for, what's their leverage, what's our leverage. It's not just about the words on the paper, which is all that you can really like give to the AI tool, right? Like somebody mentioned in the previous panel humanity and like keeping the humanity in. I think that's what people bring to this, and I think that's what lawyers bring to this, and it's this whole idea of like deals. We talked also in the last session about like statistics and analysis, and where AI just won't get it right is because you're sitting at the negotiating table and somebody loses their temper, and like nobody could have seen that coming, and suddenly the deal's gone completely off into left field, and everybody's like trying to regroup because someone's angry that they weren't getting what they wanted. Like, so I do think like that human element of reading people and reading situations and understanding what's driving people is never going to go away.
Yeah, I think to that question of what can law students do is it's not just about developing those technical competencies and the legal knowledge you need to vet the output of those applications, but to your point, it's those other soft skills that set you apart from a technology. It's your empathy, your judgment, your critical thinking, your negotiation and communication skills, your business acumen. That is your value add as a human in this world of technology. So you can kind of focus on how do I become a fully AI-enabled lawyer? It's the technical competencies, it's the legal competencies, and it's that kind of X factor piece as well.
We really took your question, Ran.
Yeah.
There were other questions, I think.
I was just going to say, we all talk about the negative side of the downside and the problems with AI and all the mistakes that it makes without really acknowledging all the mistakes that humans make.
Absolutely.
It's interesting what we're comparing it to. So people talking about we're going to use AI and then I'm going to go to the degree. That's not what I compare the AI to. I compare the AI to how does the AI research compare to second-year associate's research, and also speed matters, and then you're able to take it over. And I appreciate you guys are from big firms. I think it is different in the smaller firms where we deal in specific areas of law where we pretty much know what the law is and we need to look things up. But to the point about the AI insurance thing, there's actually a study done and it's referred to in Gladwell's book, Talking to Strangers, where they do bail hearings, and they look at the record from the bail hearings where the judge saw the accused, where the judge did it on paper, and AI did it based on what the law is, and the AI outperformed both in terms of reoffending. So I think we have to be careful to just dismiss AI as being inferior to humans when clearly it is accelerating at a pace that humans are just not.
Yeah,
getting.
I think that's totally right. Like the standard is not perfection. It can't be. The standard's not perfection. We're so imperfect.
It's a ridiculous standard.
Yeah.
And
like self-driving cars, right?
I think some of the other things that just for some law students maybe understand. As a lawyer in a small firm, I have conversations with clients daily about cost. Daily. Just like I've never asked how Apple built my watch, they don't ask me how I'm going to solve their problem. They don't ask me what tools I'm going to use or who's going to do the work or what anything of those kinds. They just want to solve the problem. And I think what AI does is it lends a really good opportunity to actually value build. And one of the things that we're talking about is why law students are still going to have a job is because ultimately the job is problem solving. And this is another tool that we can use to solve the problem. I think what lawyers have done out of sheer laziness is we build by the hour because we just don't ever want to lose on a file. Right? We don't ever want to say I lost on that file rather than making up on the straightaways. We get caught by these things where people say, well, you can't bill for that. You can't put any hours in for that. Well, sure. But you could say to somebody, this is going to be $5,000. Do you care how we get it done? And the person says, no, I agree. I just want to get it done. I'm paying for the certainty. I want it done today. But I think with the AI model and switching pricing here, I think you are going to see more value-based pricing. We're certainly using it a lot. I use AI every day in my research program called Lexi. Is it 100% right every single time? No, but then what's missing if you're going to litigate a case and just take this paragraph that either whether it's an associate or whether it's an AI program, and then marshal your case forward on that. When you find the case you think is right, you haven't got to read it, you understand what evidence they used. So I just get concerned when I see these panels that are, monster panels in these things, where it's coming, and it's going to be, it's going to be better than humans, and it's probably going to be there in a couple of years. I just wish that we could value ourselves as lawyers more as problem solvers. How do I solve this problem? Who cares what the tool does? And how do we value that? What are people willing to pay for? And we don't get into things. I would never say to someone that I'm going to cut off my research. But I may agree that down the road, I don't charge for research because it takes me 2 seconds. I know from there. So it's just, I don't know what it's like in the big firm.
Yeah.
I'm interested in why it's.
No, I think that's right. I mean, sometimes too, you have to bring the client into the conversation, right? Like, and that's around like your assumptions and your disclaimers and stuff, where you're saying, look, like we're and they. In a case like the easy example is e-discovery, where even now the courts have understood, like, okay, we're taking an approach where we know that we're going to be like 93%, accurate on the fact that these are the 4 corners of the documents that are relevant or privileged or whatever it is, right? And so we're not operating in a world that's like 100% perfect, and that's because all the players have agreed that like it's just not reasonable, it's not commercially reasonable, it's not practical, it's too expensive, it's too time consuming, and all of that. So I think
earlier too, when you're saying about people using it in their life, when they use it in their life, then it makes its way to the court. So the ability of people to generate text messages, email, we talk about access to justice. I mean, the ability of people to generate stuff that then has to be reviewed, even in like a divorce proceeding. It's almost like it doesn't seem to matter, because the faster our ability to do AI is in our practice, the faster the general public can just create stuff. And then now they create videos, now they create deep fakes, and they're changing emails and things like this. So, it's not going to really change the level of skill that's required to marshal a case forward, because it's just another tool. But I think to your point earlier, it's just like we're using it for life.
Yeah.
So if we could go back and do 1986 cases with today's AI, they would make a huge difference. 10 minutes.
And Matt, I'm not here to tell you you can't use it. I hope my message is that yes, there are definite advantages to using these tools, and you should become familiar with them and use them to your benefit. But just with a message of use guardrails, use caution, use your common sense, remember what your obligations are, remember to whom your obligations are. But I'm certainly not here telling you you can't use these things. In fact, you should, and we're probably not far away from the point where the guidance on some aspects will be you should use it, because otherwise you're inefficient to the detriment of your client.
Yeah.
So I'm not here to tell you you can't use it. I'm just telling you be smart about it. And at the end of the day, it's an accountability issue, right? If the machine is wrong, it doesn't care because it's your name that's on the paper, right? So, again, use it, but in the context of your professional obligations, your ethical obligations, and just be careful, but otherwise have at it.
Yeah, and I know we're almost at time here, but I just wanted to make one quick comment. I appreciate your hearing your view from a smaller firm perspective, because a lot of the time, I hear questions like, well, I'm a sole practitioner or I'm in a boutique firm. How could I possibly afford this AI? And it's not cheap, but a lot of these applications are based on per user subscription models. So if you're a smaller firm and you have 5 lawyers, everyone does wills and estates work, or everyone does contracts work, there might only be one AI tool you need to help you, and it's going to be much more cost effective to license that for 5 users versus a large service firm that has hundreds of lawyers and all these practice areas. There's so many different legal AI tools out there for different practice areas, as well as those general use tools. And sometimes it's like you're disadvantaged by your size, because where do you even begin? And even though you might have more resources, they quickly get spread so thin. So just from that kind of access to justice perspective, and whether, sometimes we hear like, is this going to be a barrier for solo practitioners and smaller firms? And I'm optimistic that in some cases it might be better positioned than the bigger firms to adopt technology.
So we're starting to hear a clamoring from outside. That's because there's a class that's about to come in here. The good news is we're having a reception outside if folks want to stay and connect and keep the conversation going. Thanks very much to our panelists. Please join me in thanking them.